You'll never see that deposit again, kid. That apartment is trashed. Marcus Langford smirked as he stood in the doorway of what had been my home for 3 years. The place was spotless. I'd spent 2 days cleaning every surface until it gleamed. My name is Oliver Mitchell. I'm 29 years old, and I'm a quality assurance inspector for Mitchell Construction in Portland, Oregon. In that moment, watching my landlord lie to my face about damages that didn't exist, I realized he'd picked the wrong tenant to swindle. I just nodded once, handed him the keys, and said, "I understand your position, Mr. Langford." What he didn't know was that I'd documented everything. Every scratch, every mark, every flaw in that apartment had been photographed, cataloged, and time-stamped over the past month. When you inspect construction sites for a living, you develop certain habits. Thorough documentation isn't just my job, it's who I am. The warning signs had been there for weeks. Marcus had scheduled the final inspection for 4:30 p.m. on a Friday, hoping I'd be rushed. He'd brought along his nephew Derek, a cocky 22-year-old who worked for his property management company, to serve as his witness. Derek spent the entire walkthrough taking photos with his phone, making exaggerated gestures at every minor scuff mark. "Look at this damage to the kitchen counter," Derek said, pointing at a barely visible water ring that had been there when I moved in 3 years ago. I'd photographed it during my initial inspection, along with everything else. "And these scratches on the hardwood," he continued, indicating normal wear patterns that any reasonable person would expect after 3 years of careful use. Marcus nodded seriously at each of Derek's observations, scribbling notes on his clipboard. "Carpet needs to be replaced," he announced, examining the beige carpeting in the bedroom. The carpet was in excellent condition. I'd had it professionally cleaned just 2 days earlier and still had the receipt. "Paint touch-ups throughout," he added, despite the walls being pristine. I followed them silently, taking my own photos with my phone, though they didn't pay attention. When you're used to intimidating tenants, you stop noticing when someone is building a case against you. The final moment came when Marcus handed me a pre-printed form. "These repairs will cost approximately $4,800, he said matter-of-factly. "Your $5,000 deposit covers most of it, minus a $200 refund for good faith, $200. After 3 years of paying $1,150 rent on time every single month, never missing a payment, never causing problems, he was offering me $200 back from my deposit." "I see," I said calmly, accepting the form. "When can I expect the itemized list of damages and repair costs?" Marcus exchanged a glance with Derek. "This is pretty standard stuff," Derek interjected. "Carpet replacement runs about $2,000, paint job is another $1,500, kitchen repairs maybe $800, cleaning fees $500. I pulled out my phone and made a note. "I'll need receipts for all work performed, as required by Oregon state law." Marcus's expression hardened slightly. "Look, kid, I've been doing this for 15 years. Trust me, this is all legitimate." "I'm sure it is," I replied evenly. "I just like to keep good records." What Marcus Langford didn't know about me was that I'd been preparing for this moment since my lease renewal 8 months ago. That's when I'd noticed his pattern. I'd been researching tenant rights online when I stumbled across a forum thread about predatory landlords in Portland. 3 different tenants mentioned Langford properties by name, describing identical scenarios. Perfect apartments declared damaged, deposits kept for mysterious repairs, no receipts ever provided. One former tenant had sued but lost because she couldn't prove the apartment's condition when she moved out. That's when I decided to create the most comprehensive documentation system a landlord had ever encountered. I started with a complete photographic survey of the apartment, taking over 200 high-resolution images from every angle. I photographed the water ring on the kitchen counter, the minor scuff marks on the baseboards, the normal wear patterns in the carpet. Every existing flaw was documented with multiple angles and detailed close-ups. But I didn't stop there. I created a digital timeline, taking new photos. Every 2 weeks to show the apartment's consistent condition. I documented my cleaning routine, photographed the professional cleaning receipts, and maintained detailed records of every maintenance request I'd submitted to Langford's office. I also did something else that I didn't mention to anyone. I researched Marcus Langford's business practices extensively. Langford Properties managed 47 rental units across Portland. Using public records, I discovered a pattern of small claims. Court filings, tenants trying to recover deposits, Langford countersuing for damages. Most tenants gave up rather than fight. Those who pressed forward usually lost because they couldn't prove the apartment's condition when they moved in. But Marcus had made one crucial mistake with me. During my lease signing 3 years ago, his office had taken photos for their insurance records. Those photos were still on file, and Oregon law required landlords to provide copies upon request. I'd requested mine 6 months ago, officially establishing a baseline for the apartment's condition. The apartment I was leaving was in better shape than when I'd moved in. 3 days after my move-out inspection, I received Marcus's formal notice via certified mail. The deposit deduction form was exactly what I'd expected. Carpet replacement, $2,100, interior painting, $1,650, kitchen counter repair, $750, professional cleaning, $400, and administrative fees, $300. Total, $5,200, which meant he owed me negative $200 on top of keeping my entire deposit. I sat at my kitchen table in my new apartment and smiled. Then I called Jennifer Walsh, the tenant rights attorney I'd consulted 2 months earlier. "Oliver," Jennifer said when I reached her. "How did the move-out go?" "Exactly as predicted," I replied. "He's claiming $5,200 in damages to an apartment that's cleaner than when I moved in." "And you have documentation?" 547 photographs. Taken over 8 months, time-stamped and geotagged. Professional cleaning receipts. The original insurance photos from his office showing pre-existing conditions. And video footage. Jennifer paused. "Video footage?" "I recorded the entire move-out inspection," I explained. Oregon is a one-party consent state. The video shows him and his nephew pointing at normal wear patterns and calling them damage, claiming a water ring that existed when I moved in is new damage, and discussing inflated repair costs. "This is excellent," Jennifer said. "I'll file the complaint tomorrow. Under Oregon security deposit law, landlords who wrongfully withhold deposits owe double damages plus attorney fees. If we can prove willful misconduct, which this clearly is, the judge can award triple damages. So instead of owing me $5,000, he could owe me $15,000? Plus your legal fees," Jennifer confirmed. "Plus court costs. Marcus Langford is about to learn that documentation matters." The process moved faster than I'd expected. Oregon's landlord-tenant court handles security deposit disputes on an expedited basis, and Jennifer's filing was thorough enough that the judge scheduled a hearing within 3 weeks. During those 3 weeks, something interesting happened. I received a call from Derek, Marcus's nephew. "Hey, Oliver," Derek said, his cocky tone from the inspection gone. "My uncle wanted me to reach out about your deposit situation. Maybe we can work something out without going to court." "I'm listening," I said. "Look, maybe we were a little aggressive with the damage assessment. How about we split the difference? Give you back $2,500, call it even?" I paused, pretending to consider it. "That's generous, but I've already filed with the court. I'll have to discuss it with my attorney." "Your attorney?" Derek's voice cracked slightly. "Come on, man. It's just a deposit dispute. Seems like overkill. I believe in following proper procedures," I said calmly. "But I'll mention your offer to my lawyer." I didn't mention the offer to Jennifer. By then, we'd discovered something that made Marcus's situation much worse. While researching similar cases for my lawsuit, Jennifer had found a pattern spanning 2 years. Langford Properties had kept full or partial deposits from 23 tenants, claiming damages that followed identical patterns: carpet replacement, painting, kitchen repairs, cleaning fees. The amounts varied, but the categories were always the same. More interesting was what Jennifer discovered through subpoenas. Marcus had only actually performed repairs on 6 of those 23 units. The other 17 had been re-rented without any work being done, meaning he'd collected thousands in fraudulent damage claims while doing nothing. "This isn't just wrongful withholding," Jennifer explained. "This is systematic fraud. The state attorney general's office is interested." The court hearing was scheduled for a Tuesday morning in November. I arrived 30 minutes early, carrying a briefcase containing printed copies of every photograph, every receipt, every piece of documentation I'd assembled. Jennifer met me in the courthouse lobby. "Their attorney called this morning," she said. "Final settlement offer $4,000 plus your attorney fees." I shook my head. "We're here. Let's finish it." Marcus arrived with Derek and a lawyer I didn't recognize, not their usual attorney, Jennifer noted. They sat at the defendant's table, Marcus in an ill-fitting suit, Derek fidgeting with his phone. Judge Richardson called the case. Jennifer stood to present our evidence, and for the next 45 minutes, she methodically destroyed Marcus's credibility. She started with the original insurance photos from Langford Properties' own files, showing the apartment's condition when I moved in. Then she displayed my move-in photos, taken the same day, showing identical conditions. Next came the timeline photos, proving the apartment's consistent maintenance over 3 years. Your Honor, Jennifer said, the defendant claims carpet replacement was necessary due to tenant damage. I'd like to show the court what this damaged carpet actually looked like. She projected my final photos of the bedroom carpet onto the courtroom screen. Even the judge leaned forward. The carpet was pristine, vacuumed, professionally cleaned, without stains or significant wear. Compare that to the original condition, Jennifer continued, switching to the insurance photos. The carpet actually improved during Mr. Mitchell's tenancy due to his professional cleaning. Marcus's attorney objected, claiming the photos could have been staged or edited. That's when Jennifer played her trump card, the move-out inspection video. The courtroom watched in silence as Marcus and Derek walked through my apartment, pointing at normal wear patterns and calling them damage. The audio was clear. This water ring is definitely new, Derek said in the video, pointing at the kitchen counter. Got it, Marcus replied. That's probably $300 right there. Jennifer paused the video and projected the insurance photo showing the exact same water ring from 3 years earlier. This new damage that Mr. Langford charged $750 to repair existed when Mr. Mitchell moved in and was documented by the defendant's own insurance company. The judge's expression grew stern. Continue the video, counselor. The worst moment came when the video captured Marcus and Derek discussing their strategy in what they thought was a private moment. Easy money, Derek muttered, as they examined the pristine bathroom. Kid's a neat freak, but Dad says we bill for repainting anyway. Standard procedure, Marcus replied. They never fight it. Judge Richardson's face hardened. When the video ended, he looked directly at Marcus. Mr. Langford, would you like to explain why you're charging for repairs to pre-existing conditions and billing for work you described as standard procedure, regardless of actual damage? Marcus's attorney requested a brief recess to consult with his client. 5 minutes later, they returned with an offer to settle for the full deposit amount plus my attorney fees. Too late, Judge Richardson said curtly. I've heard enough evidence to make my ruling. The judge found that Marcus had willfully and fraudulently withheld my security deposit, violated multiple provisions of Oregon's landlord-tenant law, and engaged in deceptive business practices. The ruling was comprehensive. Return of my $5,000 deposit, triple damages under Oregon's willful misconduct provision, $15,000, my attorney fees, $4,200, court costs, $350, total judgment, $24,550, but Judge Richardson wasn't finished. Mr. Langford, he said, this court is referring this matter to the Oregon Attorney General's office for investigation of potential criminal fraud. I'm also ordering you to provide complete records of all security deposit withholdings for the past 3 years. Marcus went pale. Derek looked like he might be sick. As we left the courthouse, Marcus's attorney approached Jennifer. My client would like to discuss a payment plan for the judgment. Tell your client he has 30 days to pay the full amount, Jennifer replied. After that, we begin asset seizure proceedings. 2 weeks later, I received a certified check for $24,550. Attached was a note from Marcus's new attorney explaining that his client was restructuring his business practices and would like to avoid any further legal complications. I deposited the check and sent a copy of the transaction to the Attorney General's office, along with my complete file of documentation about Langford Properties' business practices. 6 months later, I read in the Portland Tribune that Marcus Langford had agreed to pay $127,000 in restitution to former tenants as part of a settlement with the state. His property management license was suspended for 2 years, and he was required to complete courses on landlord-tenant law before reapplying. Derek, it turned out, had been recording their fraudulent practices on his personal phone for months, apparently planning to blackmail his uncle later. When the Attorney General's office offered him immunity in exchange for cooperation, he provided evidence that led to criminal charges. I never felt vindictive about the outcome. What I felt was satisfaction. The quiet contentment that comes from thorough preparation meeting dishonest opportunism. Marcus Langford had built his business on the assumption that tenants were easy targets, too naive, or too busy to fight back properly. He'd miscalculated badly with me. A year later, I received a letter from a former tenant of Langford Properties, who'd gotten my contact information through the Attorney General's office. She thanked me for fighting the case and mentioned that she'd used my documentation methods when moving out of her new apartment. Her landlord had returned her full deposit without question. I framed that letter and hung it in my home office, next to my quality assurance certifications. Sometimes the most effective revenge isn't dramatic confrontation or emotional outbursts. Sometimes it's simply being more thorough, more prepared, and more professional than the person trying to take advantage of you. Documentation, as I learned long ago in construction, is everything. Measure twice, cut once, and always keep the receipts. Marcus Langford discovered that the hard way, $24,550 at a time.